If you're a green card holder, visa holder, or have family members navigating the U.S. immigration system right now, what I'm about to share in this video could directly impact your travel plans and peace of mind in 2026. There's been significant discussion and concern about a potential new visa ban under the Trump administration. This year, social media is flooded with panic, rumors, and conflicting information. And the question that keeps coming up over and over again is this: are green card holders safe to travel outside the United States? Right now, I'm going to give you the facts. We're going to separate verified information from speculation, explain exactly what a visa ban means, who it affects, and most importantly, what green card holders need to know before making any international travel decisions. This is not about politics. This is about your rights, your status, and your family's future. Stay with me until the end, because we'll also debunk dangerous myths circulating online and give you practical guidance based on what immigration attorneys are actually advising their clients. In 2026, let's break this down clearly and carefully. To understand the current situation, we need context. During President Trump's first term from 2017 to 2021, immigration policy became one of the most actively managed and controversial areas of federal action. The administration issued numerous executive orders and proclamations affecting both non-immigrant and immigrant visa categories. The most well-known action was the travel ban, officially titled Protecting the Nation from Foreign Terrorist Entry into the United States, which went through multiple versions. It restricted entry from several predominantly Muslim countries and was challenged extensively in courts, before being upheld in modified form by the Supreme Court. Beyond travel restrictions, the first Trump administration implemented stricter vetting procedures, increased denial rates for certain visa categories, expanded expedited removal policies, and pursued changes to asylum processing and family-based immigration. After the Biden administration took office in 2021, many of these policies were reversed or modified. But with President Trump's return to office in January 2025, immigration enforcement and visa policy have once again become areas of active policy development. It's important to note that as of now, in late January 2026, specific details about comprehensive new visa bans are still emerging. What we're seeing is a combination of proposed actions, leaked draft orders, and preliminary announcements that have not all been finalized or implemented. This is why separating fact from speculation is so critical right now. What is the reported 2026 visa ban? So what exactly is a visa ban? In U.S. immigration law, a visa ban is typically an executive action or presidential proclamation that suspends or restricts the issuance of certain types of visas to nationals of specific countries or to individuals meeting certain criteria. Visa bans can target non-immigrant visas like tourist visas, student visas, and work visas. They can also target immigrant visas, which are for people seeking to become lawful permanent residents. The legal authority for such bans comes from Section 212F of the Immigration and Nationality Act, which allows the president to suspend an entry of any class of aliens if their entry would be detrimental to the interest of the United States. Now here's where we need to be very careful about language. As of this recording, there have been discussions, reports, and leaked drafts regarding potential visa restrictions in 2026. Some reports suggest targeting specific countries based on security concerns. Others mention restricting certain employment-based visa categories. Some discussions have centered on asylum and refugee admissions, but not all of these discussions have resulted in official, legally binding executive orders yet. What we can say with certainty is that the Trump administration has signaled an intention to pursue stricter immigration controls, enhanced vetting, and potentially reduced visa issuance in certain categories. The exact scope, timeline, and implementation details are still developing. This is why it's essential to distinguish between three things: rumors circulating on social media, proposed policy changes that are being discussed or drafted and confirmed, executive actions that have been officially signed and published. Always verify information through official government sources, like the Department of Homeland Security, the State Department, and USCIS before making major decisions. Who would be affected by a new visa ban? Let's talk about who typically gets affected. When visa bans are implemented, tourist visas, specifically B1 and B2 visas, are often among the first categories impacted. These are temporary visas for business visitors and tourists. During the first Trump administration, enhanced vetting and country-specific restrictions heavily impacted tourist visa issuances. Student visas, including F1, J1, and M1 visas, could also be affected. International students contribute significantly to U.S. universities, in the economy, but visa restrictions can limit admissions and create processing delays. Work visas like H-1B L1 and O-1 have historically been areas of focus for stricter enforcement. The H-1B program in particular has faced increased scrutiny, higher denial rates, and proposals for reform. L1 intracompany transfer visas and O-1 extraordinary ability visas could also see changes in processing standards. Family-sponsored and employment-based immigrants waiting for immigrant visas at U.S. consulates abroad could face delays if new restrictions are implemented. This would affect people who have approved petitions but are waiting for visa availability and consular processing. It's crucial to understand that visa bans typically apply to people applying for new visas or seeking entry into the United States. They generally do not automatically revoke visas that have already been issued, though in some cases, previously issued visas can be subject to additional screening or administrative review. Are green card holders safe to travel? Now we get to the question everyone wants answered. Are green card holders safe to travel outside the United States? In 2026, let me start with the legal foundation. Lawful permanent residents, commonly called green card holders, are not visa holders. This is a critical distinction. When you become a lawful permanent resident of the United States, you are given the right to live and work permanently in the country. You are not traveling on a temporary visa. Green card holders have legal protections that visa holders do not have under U.S. immigration law. Permanent residents have the right to return to the United States after temporary travel abroad, provided they have not abandoned their residence and they meet re-entry requirements. So when we talk about visa bans, those restrictions typically apply to foreign nationals seeking to enter the United States. Dates on visas, they do not, as a general rule, prevent lawful permanent residents from re-entering their country of residence. However, and this is important, green card holders are still subject to inspection at U.S. ports of entry by Customs and Border Protection officers. During inspection, CBP officers can ask questions about your trip, review your travel history, and verify that you have not abandoned your permanent residence. They can also check for criminal issues, immigration violations, or other admissibility concerns. In past periods of heightened immigration enforcement, some green card holders, particularly those from countries subject to travel bans or enhanced vetting, have experienced longer secondary inspections at airports. This can be stressful and time-consuming, but it does not mean re-entry is denied. The key point is this: having a green card gives you a legal right to return to the United States that visa holders do not have. A visa ban targeting visa applicants does not strip you of your lawful permanent resident status. That said, there are specific situations where green card holders can face complications, and we'll address those in the next section. Difference between visa holders and green card holders. Let's make sure everyone understands the fundamental difference between visa holders and green card holders, because this confusion drives a lot of unnecessary panic. Visa is a document that allows a foreign national to request entry to the United States for a specific purpose and a limited period of time. Visas are temporary, they expire. They are tied to specific activities like tourism, study, or work. A green card, on the other hand, is proof of lawful permanent residence. It's not temporary, it doesn't expire in the same way a visa does, though the physical card itself needs to be renewed every 10 years. Permanent residents have the right to live in the United States indefinitely. Visa holders must maintain their non-immigrant status and cannot stay beyond their authorized period without risking violations. Green card holders are residents. They can work for any employer, change jobs freely, and live anywhere in the United States. When a visa ban is issued, it typically restricts the issuance of new visas or the entry of visa holders from certain countries or categories. It does not cancel existing green cards. This is why immigration attorneys emphasize that green card holders are in a fundamentally different legal position than people on temporary visas. However, green cards can be taken away in certain circumstances such as fraud, abandonment of residence, or certain criminal convictions, but those are case-specific issues, not automatic results of a visa ban. Travel risks to be aware of, balanced and factual. While green card holders generally have strong re-entry rights, there are specific situations that can create complications. Lengthy trips abroad. If you stay outside the United States for an extended period, typically 6 months or more, CBP officers may question whether you've abandoned your permanent residence. If you're planning to be abroad for more than 1 year, you should apply for a re-entry permit before you leave. Expired or conditional green cards. If your green card has expired, you should renew it before traveling. While your status as a permanent resident doesn't expire, having an expired card can and create issues at the border and with airlines. If you have a conditional green card based on marriage or investment, and it's expiring soon, make sure you file your I-7051 or I-8.29 petition to remove conditions on time, criminal or immigration violations. If you've been arrested, convicted of certain crimes, or have outstanding immigration violations, you could face additional scrutiny or even removal proceedings upon re-entry. Not all crimes make you deportable, but serious offenses can jeopardize your status. Pending applications. If you have pending applications like I-7051 to remove conditions, E-829 for investors, I-4805 for adjustment of status or N-400 or naturalization, traveling internationally can sometimes complicate your case. In some situations, leaving the country while an application is pending can be considered abandonment of that application. For naturalization applicants specifically, extended travel can disrupt the continuous residence requirement needed for citizenship. These are important considerations, but they're not new to 2026. These have always been factors that green card holders need to manage carefully. What immigration lawyers are advising in 2026. So what are immigration attorneys telling their clients right now? First, carry proper documentation when you travel. This includes your valid green card, passport, and any supporting documents that show ties to the United States, evidence of your job, home, family, and community connections. Second, monitor official updates from the Department of Homeland Security, the State Department, and USCIS. Don't rely solely on social media or news headlines. Go directly to government websites for confirmed policy changes. Third, if you have concerns about your specific situation, such as pending applications, criminal history, or prolonged absences, consult with a qualified immigration attorney before traveling. Every case is different and personalized legal advice is essential. Fourth, avoid making panic-driven decisions, canceling important family trips, business travel, or medical appointments abroad out of fear, without understanding the actual risk to your specific situation, can be unnecessary and costly. Fifth, if you're considering applying for U.S. citizenship and you're eligible, many attorneys are advising clients to move forward with naturalization applications. U.S. citizens have absolute rights to enter the United States and cannot be subject to immigration enforcement. Naturalization provides the strongest protection. Again, I'm not an attorney, and this is not legal advice, but these are common sense recommendations based on what experienced immigration lawyers are sharing with a broader community. Common myths and misinformation. Let's debunk some dangerous myths circulating online right now. Myth number 1. All green card holders will be banned from traveling. This is completely false. There is no legal mechanism or proposed policy that would ban all green card holders from traveling. Permanent residents have a legal right to return to the United States. Visa bans target visa applicants and certain visa holders, not permanent residents. Myth number 2. If you leave the U.S., you'll automatically be denied re-entry. Not true. Millions of green card holders travel internationally every year, without incident, as long as you haven't abandoned your residence, don't have criminal issues, and have proper documentation. You have the right to return. Myth number 3. Visa bans cancel approved green cards. False. A visa ban does not retroactively cancel lawful permanent resident status. Once you have been admitted to the United States as a permanent resident, your status continues unless it's revoked through formal removal proceedings or you voluntarily abandon it. Myth number 4. Green card holders from certain countries will be stopped at the border. While it's true that during periods of enhanced vetting, some green card holders may experience longer inspection times, particularly if they're from countries subject to additional scrutiny, this is not an automatic denial of entry. CBP can ask questions and conduct secondary inspections, but they cannot arbitrarily deny entry to lawful permanent residence without legal cause. Myth number 5. You need to rush back to the U.S. immediately. Unless you have specific issues like an expiring re-entry permit, pending removal proceedings, or you've been abroad for many months, there's no reason to panic and rush back. Make informed decisions based on your actual circumstances. Don't let fear-mongering drive your choices. Verify information and consult professionals. How this could impact families, workers, and students. Even if green card holders themselves are not directly targeted by visa bans, these policies can have ripple effects on families, employers, and students. Family reunification delays. If visa bans restrict the issuance of immigrant visas at consulates abroad, family members of U.S. citizens and green card holders waiting for their green cards could face significant delays. This separates families and creates emotional and financial hardship. Employers and international workers. Companies that rely on international talent through H-1B, L-1 and other work visas could face hiring challenges. Employees on work visas may experience uncertainty about renewals and extensions. This impacts business operations and individual career planning. Students and exchange visitors. Universities could see reduced international student enrollment. If F-1 and J-1 visa issuance becomes more restricted, international students contribute billions to the U.S. economy. And in rich academic environments, restrictions create competitive disadvantages for U.S. institutions. For green card holders specifically, the impact is often indirect. You might have family members stuck abroad waiting for visas. You might work for a company struggling to bring in specialized talent. You might have children who are international students facing visa uncertainties. These broader policy shifts affect entire communities, not just individual visa applicants. What to expect next in 2026? So what can we realistically expect in the coming months of 2026, based on historical patterns from the first Trump administration and the current political environment? Here are possible scenarios. Scenario 1, gradual implementation of targeted restrictions. We may see executive orders that impose country-specific visa bans, enhanced vetting requirements, or restrictions on certain visa categories. These would likely be rolled out incrementally and face immediate court challenges. Scenario 2, increased enforcement without formal bans. Instead of broad bans, the administration could simply increase denial rates, add administrative processing requirements, and make visa applications more difficult. Without formally banning categories, this creates de facto restrictions without legal proclamations. Scenario 3, court intervention and legal limits. As with the first Trump administration, any sweeping visa restrictions will likely be challenged in federal courts. Legal challenges can delay implementation, modify policies, or strike them down entirely. The judicial system serves as a check on executive authority. Scenario 4, policy negotiations and modifications. Immigration policy often goes through multiple iterations. Initial proposals get modified based on practical implementation. Challenges, diplomatic concerns, economic impacts, and legal constraints. What's critical to understand is that major immigration policy changes don't happen overnight. There are procedural requirements, legal challenges, and administrative realities that slow down implementation. This means you have time to stay informed, plan appropriately, and make decisions based on actual, confirmed policies rather than proposals or rumors. Emotional reassurance and practical advice. I want to take a moment to address the emotional toll this uncertainty creates if you're a green card holder. You've already been through a long, expensive, and stressful immigration process. You've built a life in the United States. You have a home, a job, relationships, and roots here. The idea that your ability to travel freely and return home might be threatened is deeply unsettling. I understand that this is your life we're talking about, not abstract policy debates. But here's what I need you to remember. You have legal rights. Lawful permanent residence is a protected status. You are not in the same vulnerable position as someone on a temporary visa or someone without status. The United States has legal systems, due process protections, and constitutional safeguards. Immigration policy cannot simply strip away your rights. Without legal justification, that doesn't mean the system is perfect or that you won't face frustrations and challenges. But it does mean you're not powerless. The best thing you can do right now is stay informed. Through reliable sources, maintain your permanent resident status carefully. Keep your documentation current, and consult with immigration professionals when you have questions specific to your situation. Don't let fear control your life. Don't cancel important trips or make major life decisions based on unverified rumors. Gather facts, assess your personal circumstances, and move forward with confidence in your legal status. You've earned your green card. You belong here, and you have the right to continue living your life. Final summary and call to action. Let's bring everything together. We've covered the Trump immigration updates for 2026, explained what visa bans actually mean under U.S. immigration law, and clarified who these restrictions typically affect. Most importantly, we've answered the central question: are green card holders safe to travel? The answer is yes, with reasonable precautions. Green card holders are not visa holders. You have lawful permanent resident status and the legal right to return to the United States. Visa bans targeting visa applicants do not strip you of your permanent residence, however. You should be aware of specific risks like lengthy trips abroad, expired documentation, criminal issues, and pending applications that could complicate re-entry. The best approach is to stay informed through official government channels, carry proper documentation when traveling, and consult with immigration attorneys for personalized advice based on your specific circumstances. Don't believe myths about automatic bans or denials. Don't panic, but do stay vigilant and prepared. Immigration policy in 2026 will continue to evolve, and we'll be here to break down every major development with facts, clarity, and balance. If this video helped you understand the current situation, please hit that like button and subscribe to this channel. We're committed to providing accurate, reliable immigration news without sensationalism or fear-mongering. Leave a comment below and let me know. Are you a green card holder planning international travel this year? What questions do you still have? What concerns are weighing on your mind? I read every comment, and your feedback helps shape future videos. Share this video with anyone in your community who needs clear, factual information about travel safety for green card holders in 2026. Thank you for watching. Stay informed, stay calm, and stay empowered. I'll see you in the next update.